Hello everyone. This video will give an introduction to the intellectual property system. Let's start.
I wonder how can intellectual property helps to protect my idea. Let's go ask Professor. Professor, I wonder how can intellectual property helps to protect my idea? Could you please explain it to me?
Sure. Intellectual property. Intellectual property rights can be defined as the rights given to people over the creations of their minds. They usually give the creator an exclusive right over the use of his/her creations for a certain period of time. Intellectual property rights are divided into two main categories. First is copyright and rights related to copyright. Second is industrial property. Industrial property include the followings. First is pretty patent, or you can call it invention. Second is design patent. Third is trademark. And lastly, trade secrets. Protection system. Copyright protection system is unregistered system, which means it is automatically protected. Industrial property is registered system, which means you need to register to protect your invention. There are four components of intellectual property systems. The four components includes IP creation, IP protection, IP utilization, and IP enforcement. The TRIPS Agreement. The TRIPS Agreement stipulates a set of minimum standards for the protection of intellectual property rights that each member must follow in accordance with their individual national laws. All members have been obligated to uphold the national treatment responsibilities, equal treatment for domestic and foreign individuals and businesses, and most favored nation treatment, non-discrimination between foreign individuals and businesses. The TRIPS Agreement sets out the minimum standards that all WTO members must follow. For example, if you are a creator in one of the WTO member countries, your literary and artistic works are automatically protected in all the other WTO member countries. These are some example of WTO countries: Thailand, USA, and China. Do you have any further questions?
The concept of copyright is new to me. Could you please explain it?
For copyright purposes, artistic work includes paintings, sculptures, cartoons, and photographs. For copyright purposes, literary work includes books, anthologies, articles from magazines and newspapers, reports, conference papers, working papers, computer software, and programs. Acquisition of copyright protection is automatic protection. If you create artistic work or literary work, it is automatically protected because the copyright system is an unregistered system. Do you have any further questions?
What happens when copyrightable works expire?
The terms of copyright duration are life plus 50 years after the time period expires. It goes into the public domain. This means others can use your expired copyrightable works without your permission. The exclusive rights to reproduction, adaptation, publication, performance, and display are entitled to the copyright owner only. Remember, you must obtain permission before using any of his or her literary or creative creations.
Professor, I have question. What happens if I use his or her literary work or artistic work without his or her permission?
Copyright infringement has two types: criminal infringement and civil infringement. Criminal infringement will occur when someone steals your work or uses your work without your permission. Civil infringement will occur when you make a contract with the owner of your work but you didn't follow the rules of the contract. Will be civil infringement if you use copyrightable works without permission for your school project video. The owner of the copyright can take you to court for copyright infringement. Remember the important thing: a licensing contract will help you to avoid copyright. Furthermore, you need to make sure who is the copyright owner before you sign the licensing contract.
With whom can I enter into a licensing agreement?
Signing copyright licensing contracts is known as intellectual property utilization. You must sign copyright licensing contracts with the copyright owner only. In addition, I will explain more about the copyright recordation process in Thailand. The Intellectual Property Office receives and verifies documents as part of the copyright registration process in Thailand. Applications are accepted and reviewed after submission, and certificates of copyright registration are then issued. The entire process typically takes 2 to 4 months to finish.
How about other intellectual property? Could you please explain it?
Types of patent. Basically, there are two common types of patent, including utility patent, or you can call invention patent, design patents. Some countries have plant patents like the US. All types of patents are granted by the government to inventors or industrial designers, giving the inventor or industrial designer the right to stop others, for a limited period, from making, using, or selling the invention without their permission. For the patent protection system, you have to register your invention or your industrial design with the government agency in the country where you want to protect it. The name of authority for intellectual property. In Thailand, the government authority is the Department of Intellectual Property, or DIP. In the US is the United States Patent and Trademark Office, or USPTO. In China is the Chinese State Intellectual Property Office, or STPO.
Is a patent valid in every country?
Protection is a territorial right. It means it is only protected in the countries where you register your invention or industrial design. For example, my invention has been granted a patent in Thailand, which means my patent is only protected in Thailand. Remember, if you are an inventor, you need to check the 3 requirements for patentability before filing a patent application. There are 3 patentability requirements, including novelty, newness, usefulness, capability of industrial application, and non-obviousness. For example, if someone already filed the same invention as yours before you file a patent application, this case is lack of novelty. The first to file rule is in use for patents, where the owner has the right to seek a patent when inventing a creation for competitive purposes, and the first person to file will have priority for a patent to sell the invention. Example: if you and your competitor create the same invention under the first to file rule, who files the patent application first will have the priority for a patent. Remember, the term patent duration is 20 years counted from the filing date, and the term of design patent protection is 10 years counted from the filing date. That means your work will be protected right after you file it, not after your invention is granted a patent. For example, Mr. A is an inventor and files his patent application in Thailand on November 23, 2019. His term of patent protection is counted from November 23, 2019, which is the date of his patent application. The owner of the patent has the exclusive right to stop anyone who is commercially made, used, distributed, imported, or sold by others without the patent owner's consent.
If I want to sign a licensing contract to contribute his or her invention, with whom can I sign a contract?
If you want to sign a patent licensing contract, you have to make sure who is the patent owner, because in some countries, such as Thailand, the patent owner includes the patent transferee.
If someone uses his invention patent without his or her permission, who has the right to enforce it?
I will let you know about patent enforcement. Patent enforcement is only available to the patent owner, according to patent law. If you use his or her patent without permission, you might be sued for patent infringement. Anyways, that's it for the lesson I have for you.
Thank you so much, Professor. I have gained a lot of knowledge about intellectual property.
You are welcome. I hope you have learned some useful information from this.